Well, thank you, Jeff. It's a great honor to be here at this inaugural conference of the Hale Institute at this new college. Will you change the name once you're well established? I don't know. And it's also an honor to follow that very thoughtful introduction, which shows such a clear sense of what we're facing. When faced with criticisms of our forebears for their acquiescence in institutions such as slavery or the legal incapacity of women, I like to respond by asking what injustices in our society are invisible as injustices today to us that 100 years from now, our descendants will shake their heads in disbelief that we consider normal. Usually the critics recognize the paradox. If these injustices really are invisible, how can we even guess? Sometimes a student will suggest abortion, or another will wonder about burning petroleum products or eating meat. And actually, these may be closer to the mark, since arguments about justice and injustice in human affairs are endemic to the human condition and can be documented from almost as long ago as we have written records. After all, the argument against slavery is at least as old as Aristotle. He reports it, but he doesn't seem to accept it. And the argument for the equality of the sexes is at least as old as Plato, whose Socrates in the Republic seems to adopt it. My concern here is the opposite. What good and just institutions and practices persist in our society unnoticed or taken for granted, even by us? My candidate for that distinction is the common law, the ancient customary law of England, carried over to the colonies and made the basis of law in all of the original states and all but one of those subsequently admitted to the Union. And as I will discuss today, critical to the establishment of the Constitution of the United States and thus formative of the law of our country as a whole. Some of these institutions, practices, and rules that come down to us from common law are evident in the Constitution's text. For example, the requirement of a warrant for search or seizure, of trial by jury, indictment by grand jury, the privilege against self-incrimination, the prohibition against double jeopardy, the finality of jury verdicts, and indeed the concept of due process itself, explicitly mentioned in the Constitution's amendments. Others remain unwritten and are arguably included within the listed rights or else they're implicit in the concept of due process. For example, the presumption of innocence and the view that verdicts be rendered only if offenses are proven beyond a reasonable doubt. Moreover, I think that the term judicial power in Article 3 of the Constitution should be interpreted to mean, as it was certainly interpreted to mean in the founding generation and throughout the 19th century, to mean a power that's vested according to the practices of common law, and thus a power shared by jury and judge, the former charged to find the facts and the latter to declare the law, with judges typically appointed from the bar and expected to consult precedents as well as statutory texts in rendering their decisions. In addition, the constitutional guarantees of liberty and property make implicit reference to the way these were defined in state law, and whether at issue was real estates, contracts, familial relations, or even basic criminal law, these matters were settled originally by common law, with such adjustments the states made by legislation. And although I've now made mention of the 18th and 19th centuries, I should be clear that leaving aside these last matters of state law, all the rest remains emphatically a part of our law in the 21st century. And even many of the state law matters persist, as Professor McLeod will explain, or else persisted until only yesterday. What then is common law? Common law is the unwritten law of England, held in the 17th century at least, to have existed from time immemorial, that is, so long as, here's the phrase, the memory of man runneth not to the contrary. I think that actually means only since Grandpa's time, right? Because you knew grandfather, and so nobody remembers, you ever heard, nobody remembers doing it any other way. That's the idea. It's customary law, as it was implied in the King's Courts in England, specifically the Court of Common Pleas for matters involving property, and the Court of the King's Bench for crimes. Records of judicial decisions were written evidence of this unwritten law, and these came to be known as precedents, which were held to have the force of law because justice required that similar cases be similarly decided. Common law was not the same as natural law, although both were unwritten, since common law was more specific in its determination of points of law on which natural law might be ambiguous or indifferent, was the phrase. For example, the question of who inherits an estate. But it was generally thought that nothing in common law could contradict the law of nature, which was, after all, the law of God. It was sometimes said, actually the saying is attributed to Sir Matthew Hale, that Christianity is a part of common law. But this meant, again, I think, that nothing in common law contradicted Christian doctrine, and maybe also that the Christian understanding of the person, Christian anthropology, one might say, helps explain the reason behind some common law rules. For example, seeing the presumption of innocence as an effect of Christian charity. There were, after all, separate ecclesiastical courts, and canon law was seen as separate from common law, the concerns of the latter being chiefly temporal rather than spiritual. Numerous maxims of justice, many attributable to classical antiquity, were also incorporated into common law. For example, that no one should profit from his own wrongs, or that no one should be a judge in his own case. And these were made part of the common law not necessarily as rules specific enough to solve particular cases, but as maxims that might help in the interpretation of precedents and statutes. Speaking of statutes, it was a rule of common law that a statute of Parliament could override a contrary rule at common law, though common law judges often interpreted statutes that altered the common law narrowly, and interpreted some statutes as simply declaring in writing what was already the unwritten common law. Common law is law seen from the point of view of a court having to decide a case, a dispute between parties or between the state and a party, rather than law viewed abstractly as an instrument of public policy, the way a modern legislature or executive agency might think of some law they wish to enact or enforce. Sitting in judgment concerning a dispute, ordinarily about some action that took place in the past, or about a state of affairs that came about as a result of past actions. A court needs to ascertain the facts in dispute, how the law defines what should have happened, and what now needs to be done to repair the damage or correct the wrong, if indeed damage or wrong is discovered. Whereas a legislature or agency thinks about a result that might be achieved by the single law it has in mind to effect, a court is interested in whatever law applies to the dispute in question, including, of course, the law that establishes its own jurisdiction to hear the case. This orientation by the case is itself easy to take for granted, and its significance is easy to overlook. It supposes, after all, that before the state can coerce a person or a party, at least outside of conditions of war or riot or other comparable emergency, it must persuade the court of justice of its actions. It must persuade the court of the justice of its actions. And conversely, before a person can be coerced by the state on behalf of the public generally or on behalf of another citizen who's claiming a wrong, he has the right to his day in court. In other words, the common law from the beginning, remember these attributes extend back to medieval times. The common law is attentive to the individual in all his particularity, attentive to circumstances and conditions. The democratization of common law, at least in America, meant the extension of such rights and privileges to people of all conditions. Actually, the democratization of common law began in America in colonial times, an interesting development that, given its anchor in the King's Court in England, could not have been assumed. Chapter 39 of Magna Carta, itself described by the iconic 17th century common lawyer Sir Edward Coke as principally declaratory of common law, Magna Carta extends the guarantee of freedom from arrest and imprisonment except by the judgment of one's peers or the law of the land to all free men, and thus equality before the law was established in principle, though not always in practice, since most minor or local affairs were settled in manor courts, not the king's courts, which were reserved for major property disputes and major crimes. Also, local custom would, by a rule of ancient common law, supersede the custom of the realm, that is, the common law itself, in certain circumstances. Together, the guarantee of fundamental rights to all free men and the flexibility accorded local custom, all in the context of a culture of unwritten law, made it easy enough for the English colonists to carry the common law across the Atlantic with them and to modify it as local needs required. This played itself out especially in Massachusetts, where only freehold estates were established, thus without primogeniture and entail and all those other aspects of English property law. And where early Puritan legislation based on Deuteronomy was replaced as English law books made their way across the ocean and some American lawyers trained in England. By the eve of the Revolution, the Massachusetts jury had grown so strong that scholars believe they routinely decided questions of law as well as fact. But even that can be according to common law, since local custom was established in a common law court by the testimony of the jury. Of course, by then, the legislature of that colony, then and still today referred to as the, quote, general court, that legislature also had much to say about the law, at least in general terms, as of course in England, much was said about the law by the body that was still known in the 17th century as, quote, the High Court of Parliament. But in speaking of the American Revolution, I'm getting ahead of myself. Let's step back for a moment to mid-17th century England, where there were two occurrences that had momentous consequences for the future of our topic. The first of these is the English Civil War, which began as a dispute over the royal prerogative and the king's control of the courts, including Parliament, but proceeded to the trial, conviction, and execution of the king, and then to governance of the realm for over a decade by the House of Commons alone, or rather, in conjunction with the army and its chief, Oliver Cromwell, declared Lord Protector. During this time, in speeches, books, and pamphlets, the idea of the separation of powers emerges, in part to protect the executive and the courts from domination by the Long or the Rump Parliament. Interestingly, the common law persists throughout this period, not least through the efforts of Sir Matthew Hale, who in the 1640s was attorney for many of the royalists impeached and tried by Parliament, perhaps even for the king, but who later accepted appointment by Cromwell as Chief Justice of the Court of Common Pleas, reluctantly, since he believed the power of appointment rested in the king and was being usurped by Cromwell, but apparently as a prudential measure to keep the common law intact. Hale resigned when Cromwell died, and the protectorate was accorded to his son Richard, illegally, thought Hale. But Hale apparently played a key role in facilitating the restoration of the monarchy in the Convention Parliament, gaining under Charles II an appointment first to the Court of the Exchequer and later to be Chief Justice of the King's Bench. Indeed, it might be said that Matthew Hale preserved the common law of England through what might have been, to date, its most perilous trial. The second major occurrence that I want to refer to in the mid-17th century was the development of a new political theory by the radical thinker Thomas Hobbes, initially presented in a book called The Elements of Law, written in 1640s as the troubles between the king and Parliament exploded, then rewritten in exile in France in Latin as De Cive, and finally in English as Leviathan, published back in Cromwell's England in 1651, to which Hobbes returned. Intended as a universal science of politics, not specifically tied to England and its constitutional traditions and common law, Hobbes's Leviathan begins with a materialist or mechanical account of human nature, elaborates the concept of a state of nature as a war of every man against every man, reinvents natural law as precepts of reason designed to show warring men how to make peace, promotes the idea of sovereign power established by consent and empowered to do whatever is necessary to ensure peace, but most especially to make laws, now defined as sovereign commands, and to interpret and apply the laws thus made. The sovereign might be one man or one body of men. Hobbes says he prefers the latter and eventually endorses the restored monarchy of Charles II, to whom he had been tutor in Paris. But he recognizes that all forms of government have disadvantages, so science can't decide among them which is best. But his point is that political power must be unified, not divided among institutions, nor between church and state. From his earliest work, Hobbes set himself against the common law and the common lawyers, whom he saw as instigators of the divisions of the kingdom as early as the 1620s, and whose account of law he thought incoherent and productive of much mischief. In the last decade of his long life, and in and around translating the Iliad and the Odyssey, quote, because he had nothing else better to do, Hobbes wrote a book called A Dialogue Between a Philosopher and a Student of the Common Laws of England, which was published posthumously in 1681, doubling down on his critique of Coke and the common lawyers, and trying to assimilate the government of Restoration England into his theory of sovereignty. Now, Matthew Hale had seen Hobbes's work in manuscript, and he set out to refute it, leaving behind at his own death several copies of his manuscript reply. Although not published until the 20th century, Hale's essay shows that he perfectly understood Hobbes's intention and was convinced none of his arguments actually undercut the common law. Hobbes held that the sovereign, remember, it could be a monarch or an assembly, not only made law, but judged controversies under law, for otherwise a conflict might arise about law's meaning. In practice, this meant that judges should be the sovereign's agents, and to maintain the priority of statute law, they were to judge each case afresh, using their natural reason to settle each dispute according to the statutory text, or, in the absence of a clear text, by natural equity, which Hobbes considered among his laws of nature. In declaring the sovereign using his natural reason to be the authorized judge, Hobbes was consciously memorializing an event during the reign of King James I, who arrived one day in court and declared that as this was his court and he had natural reason as much as any other man, he would sit as judge in the case that day, only to be rebuked by his Chief Justice, Edward Coke, who declared that the common law was not natural reason, but, quote, an artificial perfection of reason, fined and refined by an infinite number of grave and learned men. The story is that the king rose in high indignation, and Coke fell on all four and apologized for offending the king, but not for what he said. The king then removed him, although he found his way back onto the court somehow. He was quite an operator. Hale reiterates Coke's argument. Like medicine or music or any of the other arts, excellence at law depends on long experience in its practice. That's what makes the law prepared for every or almost every circumstance and makes possible certainty and predictability in its decisions, avoiding the arbitrariness that would inevitably result from individuals sitting in judgment who, however intelligent and well-meaning, were not trained in the details of precedent and the deeply analogical reasoning from which precedents emerged. Hobbes conceded that sovereign judgment was arbitrary, settling what by nature was undetermined and fixing it unmistakably in the circumstance at hand. He staunchly rejected the guild of lawyers who considered justice their special province, which even the sovereign might enter only with trepidation and on rare occasions, just as he rejected a clergy who thought salvation was their business, independent of the state. Hale, by contrast, was confident of the settled benevolence of long-developed learning, fearing instead the despotism of an upstart ruler or thinker, and who discards all tradition and begins as if from a clean slate. Now, Hobbes is famous or notorious for his doctrine of sovereign power, his claim that the only way to avoid the miserable condition of natural enmity is for men to agree to confer on a single body all political authority, and warning that body to make only provisional concessions to other offices, reserving always the right to restore plenary authority when necessary, and to be the judge oneself of when that was necessary. Hale will have none of this, at least for England. Forms of government, he thinks, are various, and while they have many sources, original consent, as Hobbes also imagines, tacit consent through long-established custom, even conquest, it always remains possible, Hale thinks, for a people to alter their government, quote, by concessions and mutual agreements between the governors and governed, modifying even the form of sovereignty. In England, according to Hale, the laws can be traced back before the Norman conquest, which he sees as a disputed succession rather than a genuine conquest, the form of government in any event having been long adopted by custom and confirmed, if not altered, by mutual agreement. The king is the sovereign, to be sure, and his sovereign powers are, Hale lists them, to make war and peace, to give value to coin, to pardon, to serve as the origin of jurisdiction, to raise armed force, and finally to make laws. But most of these powers are defined and limited by law, especially that power of legislation, which resides in the king only with the advice and consent of Parliament. No one else can coerce the king, but the king can be directed by the laws, as acknowledged in his coronation oath, and his acts can be declared void by the courts if they contradicted the laws. To argue otherwise, writes Hale, is, quote, utterly false, against natural justice, pernicious to the government and governor, destructive of the common good and safety of the governed, and without any shade of law or reason to support them. He does not mince words. Even the king's military power is limited by law to this extent that he cannot order a soldier abroad without his consent, and that tax support for military expeditions must be obtained in Parliament. Unlike Hobbes, then, Hale is a proponent of constitutional monarchy, not an abstract advocate, but one who devoted his life and career to its defense and its reestablishment, scrupulously supportive of both the prerogatives of the king and the liberties of subjects. John Locke, his younger contemporary, was similarly an advocate of constitutional monarchy, and it's important to understand how their views are different, Hale and Locke. First, Locke begins his theory like Hobbes, from a concept of the state of nature, where men are equal, free, and in need of improvement, though Locke emphasizes the priority of material acquisition before the formation of government, saying that the latter is made to protect the property that men acquire, while Hobbes thought property could only be identified after a sovereign was in place. Hale, in contrast to both, says little about the origin of government or about human life in its absence. He seems instead to follow Aristotle and consider government itself to be natural, the critical question being how to ensure that it does justice. Second, while Locke, like Hale, distinguishes the legislative power and allows government to be divided or shared, Locke's emphasis is entirely on the making of statutes, which he defines as settled standing rules, with hardly a mention, and then when it is derogatory, of customary forms of law, as though all laws were new or subject to new modeling, not anchored in ancient tradition and the wisdom of the past. Third, Locke defines prerogative not by a list of legally circumscribed powers, as did Hale, but as the power to act in the silence of the law or even against it for the safety, if the safety of the people demands it, something Hale denies is ever necessary. Indeed, Hale thinks that giving permission for the king to act against the law is positively destructive of the common good. Finally, Hale, like Hobbes but unlike Locke, denies or at least does not proclaim a right of revolution in the people, even if he allows governmental reform and praises Magna Carta, thus implicitly endorsing the barons in their battle for their rights. Locke is sanguine about revolution because he thinks men can know when their property is threatened and can respond to the threat in an orderly way. Hale, for whom property rights are embedded in common law and who witnessed the regicide and dictatorship close up, is less confident that government can be safely cashiered and rebuilt. Now, we Americans claimed our independence from England by a revolution, and our most fundamental founding document, the Declaration of Independence, quotes Locke on the right to rebel and elaborates succinctly a theory of natural rights and government by consent that has clear Lockean resonance. It would be a mistake, however, to suppose that they are playing the same song, and thus that the American founding, even at the moment of revolution, can be understood without reference to common law. The key development between the mid-17th century phenomena I mentioned, the English Civil War and interregnum on the one hand, and the origin of liberal political theory in the writing of Thomas Hobbes on the other, the key development in between them is the so-called Glorious Revolution, It was once thought Locke wrote in its defense, but it's now known that he wrote before, and some think he was its architect. In its aftermath, the British soon adopted the theory of parliamentary sovereignty, a kind of marriage of Hobbes and Locke that paid scant attention to common law, and Parliament in the years that followed became preoccupied with matters such as the settlement concerning the Church of England, establishment but some toleration, the Union of Scotland and England, securing Protestant descent of the crown, and the construction of the British Empire worldwide. The American colonists experienced parliamentary sovereignty not as the triumph of popular rule, but as the threat of arbitrary power along Hobbesian lines. And more than once in the 18th century, as disputes between them and the mother country unfolded, they found in the common law an alternative to which they could appeal. This was not least because the common law remained strong too in England in the 18th century, and in fact experienced a sort of literary renaissance, indicated by the publication of several of the works that Hale had left in manuscript, including his History of the Common Law of England, and coming to a sort of fulfillment with the establishment of a chair in common law at Oxford, and the publication in 1765 through 69 of the lectures of the first occupant of that chair, William Blackstone. It's telling, though, that by the Revolution a decade later, Blackstone's commentaries had apparently sold more copies west of the Atlantic than on the home island. Here, it gave the colonists and the citizens of the young republic ready access to the common law in orderly and accessible form. There, it soon met its match in the writings of Blackstone's student nemesis, Jeremy Bentham, whose theory of legislation gave parliamentary sovereignty real bite. As the English in 1688 and 89 exploited the conservative rhetoric of Locke's theory, Locke says government, by innovating, was the true rebel. The people were just seeking to restore the constitutional order. So the American revolutionaries could appeal back to the common law. This is evident in the pamphlets and addresses of the 1760s and early 1770s, which emphasized the right to trial by jury, objected to warrantless searches, featured the unwritten constitutional principle of no taxation without representation, and the like. It's evident quite clearly and explicitly in the Declaration and Resolves of the First Continental Congress in 1774, a document that I hope you get the chance to read. And it appears even in the Declaration of Independence, where within Jefferson's Lockean frame, you can find the long and often overlooked list of grievances against the king and those others with whom he combined to foist on the colonies, quote, acts of pretended legislation foreign to our Constitution and unacknowledged by our laws, many of them derogatory of common law due process. Like the English during their Civil War a century before, the Americans kept their common law and common law courts intact during the Revolution, though some states, like Virginia, removed aristocratic remnants like primogeniture and entail. And Virginia soon removed as well the Episcopalian establishment. Though, since ecclesiastical law had always been separate from common law, this did not require abrogating the harmony of common law and Christian faith. Even New York State, which had no establishment, still prosecuted blasphemy in the early 19th century, with the endorsement of the American Blackstone, Chancellor James Kent. And as late as the 1820s, shortly before the end of the Congregational establishment in Massachusetts, a son of that Commonwealth, Supreme Court Justice Joseph Story, engaged in a war of words in the press with former President Thomas Jefferson, occasioned by the latter circulating an essay he had written in his Commonplace book years before on whether Christianity was a part of the common law. Story saying aye, Jefferson nay. I spoke at the outset of elements of common law in the Constitution and Bill of Rights. Common law is influential as well in early federal legislation. From the Judiciary Act of 1789, it's evident on both sides of the Alien Sedition Act's controversy. It's in the extension of common law to the territories of the West. It was settled in the case of Hudson and Goodwin in 1810 that there would be no federal common law crimes. There had been a few prosecutions of such in the Adams administration. But over the following decades, the federal courts developed a general common law to settle contract and property disputes in cases that arose within their diversity jurisdiction. Abraham Lincoln famously taught himself the law by reading Blackstone, and he always recommended the commentaries to young students seeking a legal education. Slavery, by the way, had been unknown at common law. So said Lord Chief Justice Mansfield in England in the 1772 Somerset case, a case known to the colonists and revolutionaries. So slavery in the United States was grounded only in statute, not legal custom, or at least so Justice Story ruled in Prigg, Pennsylvania in 1842. With slavery abolished after the Civil War by the 13th Amendment, common law achieved a kind of revival in late 19th century American law, as privileges and immunities and due process now bound the states as a result of the 14th Amendment. And Supreme Court justices, led by Stephen Field, invoked common law in favor of liberty of contract, while others, led by John Marshall Harlan, invoked common law in favor of the police power. What happened that in the 20th century, the common law went into eclipse and became invisible? It would go beyond my time and my capacity to do more than indicate the prime suspect, Oliver Wendell Holmes, Jr., whose redefinition of common law as judge-made law captured the imagination of generations of law professors and progressive lawyers, but thereby set the common law, or seemed to set the common law, at odds with American constitutional norms. No one doubts that the underlying cause was the need to understand vast social change. But one might doubt that Holmes's pragmatism, acknowledging no fixed principles, untethering common law from its natural law anchor, was the only available mode of understanding. Faced with his need as a good historian of the common law to account for change, perhaps less rapid, but over the centuries just as vast, Matthew Hale said of the common law that it was like the ship of the ancient hero Jason, the ship called the Argo, at sea so long that every plank was changed in the course of its voyage, but the ship, like the common law, retained its identity, though particular pieces were replaced. We need not set out to capture golden fleece to suppose that the common law, having been integral to our constitutionalism in its first few centuries, the repair of our constitutional system in its moment of crisis today might become possible if we are willing once again to harvest the wisdom in that old oak, and not just because it is old, but because it is good.